Hello and a very warm welcome to the brand new edition of Policy Watch. I'm Kriti Mishra. Today we'll take a closer look at the draft IT Rules 2018. A calling attention motion on misuse of social media and spreading of fake news was admitted in the Rajya Sabha during monsoon session of 2018. The government had conveyed to the House the resolve to strengthen the legal framework and make social media platforms accountable under the law. Accordingly, Ministry of Electronics and IT has prepared the draft IT Rules 2018 to replace the rules notified in 2011. The government intends to consult all stakeholders in the process. Public consultation on the draft rules has commenced with the timeline of submission of comments by 15th January 2019. And for more on this, I'm joined by Mr. Chakshu Roy, Head of Outreach, PRS Legislative Research, Mr. Subimal Bhattacharjee, Cyber Policy Expert, and Karnika Seth, Cyber Law Expert. Welcome to Rajya Sabha Television, all of you. Chakshu, let me open this discussion with you. Before we set the tone and tenor of this discussion and get a perspective, help us understand Section 79 of the IT Act, which is the fulcrum and pivot of these draft IT rules.
Kriti, the IT Act was made by Parliament in 2002 and it underwent a significant amendment in 2008. So the 2002 position was that if you were a network service provider which facilitated interaction between a user and a service provider, and you were just the conduit, you were held liable if either of the parties misused anything on your platform, and you had to prove two things. One, that it was done without your knowledge, and second, that you exercised due diligence to ensure that nothing outward happened on your network. Now, this was creating a fair bit of complication because a fair bit of the internet works on the basis of platforms or networks. Somebody provides the connectivity, somebody provides an area for people to come and interact. So in 2008, when the IT Act was amended, it provided an exemption for intermediaries. This exemption was available earlier, provided you prove those two things. But in the 2008 amendment, an exemption was provided that if you did not initiate the communication, if you did not choose who received the communication, if you did not tamper with it, then you would be provided an exemption and you would not be held liable for what you wrote on it or what I wrote on it, and the liability would shift to the people who were responsible for those things. And the rules were then framed in 2011 to give effect, and the rules basically said as to what are the things that the intermediaries, the service providers, the content platforms had to do to ensure that they were not liable for any misuse of their platforms.
Right. Karnika, take us through the important highlights of the draft IT Rules 2018 that would supplant the rules notified in 2011.
When we compare the two 2011 rules to 2018 as a draft, which has been proposed, there have been certain very, very prominent changes. Number one, what used to be a 36-hour guideline has been reduced to 24 hours. So that's a quick response time. The persons who are, complaining, for example, if it is an affected party, he may not be directly, he may write to them directly, but after the Shreya Singhal judgment, the interpretation of law has changed to that extent that it would be on the basis of an order of the court that the blocking of the particular web page or a website would take place, or it would be by the government agency, the authorized government agency, that gives a mandate that this has to be blocked for certain reasons, which will fall under the ambit of 19(2). Of the Constitution. So only those reasonable restrictions which would be permissible, which would be in line with what is constitutionally acceptable or permissible rather, to protect the integrity of state or the security of a state, the nation, friendly relations with other states, public morality, decency. These are the kind of grounds which are also there in the Constitution of India, and in that respect, if that is the situation, then yes, the rights of privacy or freedom of speech have to give way because there are overweighing considerations of national interest. So those things are there, but the timeline has been reduced. The response time to this, central, if there is a request for blocking, has to be within 24 hours. And then there is another, timeline of 72 hours of blocking. Finally, the blockings or the, I would say the cooperation with the law enforcement, the evidence which has to be given by the agency, the ISP or the intermediary needs to respond within 72 hours and in cooperation with the law enforcement agencies to enable them to investigate the particular offences. And then there is, there are other stipulations also which are there. For example, in the draft rules, if there is a particular, ad which is for, say, cigarettes or for alcohol or something which is injurious to public health, even those have been brought within the ambit of the rules. So there have been certain very drastic changes. And then for what period of time this evidence has to be stored. Earlier it used to be 90 days period after having complained to an intermediary that this is the kind of evidence which is available, or that blocking should be there in respect of this particular objectionable material on your site. This had to be stored for 90 days. Now it has shifted to 180 days. So the timelines have changed, but it has become more, I would say, proactive and more, the incident response time or the action time is reduced. And because it takes long for any investigation to occur, the period of evidence storage retention has been increased. So there have been quite significant changes brought about with the new draft guidelines.
So Vimal, Karnika is making a very pertinent point about national security. Now the government has said and asserted time and again that it is committed to upholding the freedom of speech and expression and also privacy for the citizens enshrined in the Constitution. But then it is equally important to vanquish the menace of fake news. Where do you spot the right balance?
See, I think as both my fellow panelists have said, the context that Chakshu brought out and as she has put out the draft rule. See, the expansion of the digital space in this country in the last 18 years, since when the first time the Information Technology Act was brought, has been tremendous. So many issues have come, so many issues of usage, where every day new people are coming in. So how do you deal with all these issues? I think we are all learning as we are going through. Even the laws or the rules, concomitant rules that are coming with the laws, they all need change. So 2011 to 2018 was a necessity. Just like in the IT Act from 2000 to 2008, the Avnish Bajaj case, after which the expert committee came and then the amendments were brought in. Right now, fake news is one of the issues that we are needing to grapple with. And I'm sure, the context in which this whole draft amendments have been brought in, that factors in that, because much of the fake news in a country like India sets a lot of violence. You would remember a few years back, a news was circulating about Northeast students being attacked and all, and everyone, trains were loaded, everyone was going away from Bangalore and all. Similarly, recent incidents of all this lynching and all. So I think the rules were required, the changes were required, the dealing of the law enforcement agencies with the various intermediaries, who are quite huge, who have huge subscribers in this country. WhatsApp is the highest now in the country, almost I think more than 25 crores users. So, and the popularity of the medium and all, and the proximity with which these devices are trusted. Nowadays, you trust more of your device than what even your neighbors or relations would say. So with all of that in context, I think we needed a far much broader encapsulation of the scenario. The question comes, how will you be able to implement all of that? Because your relationship, your engagement with all these intermediaries, and most of them are the US-based ones who have the huge followings and all, hasn't been the best. It has improved. You are maybe all the time chasing them. They are responding, but possibly not at the pace or the support that you want. So this set of rules possibly gives you a larger window to address that. But it's a question of harmonization and better implementation that would be very essential to see that you are within the confines of the law, you are within the umbrella of balancing security and privacy, and yet you are able to deliver what you really want to do.
Right. So the right balance between security and privacy. I'm coming to you, Karnika. Now, he's talking about implementation. There have been instances where criminals or anti-national elements have misused social media platforms, and that has thrown up new challenges for our law enforcement agencies. How effective would be these rules to combat those challenges?
Well, at this point, I have two views to share mainly. One is that agreed that there have been a lot of mob lynching attacks, and social media has, been a channel to, perpetrate this and also to distribute it to a large extent. There are legitimate reasons to have some sort of a regulation. On the other hand, I'm also of the view that when you technically try to control a medium like, social media platform, it becomes very challenging because the encryption keys, because there are end-to-end encryptions in platforms, and how do you decrypt that information? There are procedural challenges as well as technical challenges. One, right now, if with this new draft bill, if this gets amendments take place, then any platform with more than 5 million users will have to have no more just virtual offices but physical presence in India. It has to have a company here, a nodal head here for immediate response. Now, if that is the case, obviously accountability responsibility increases. But even if this law comes into place, will they be able to combat it? The social media, the fake news aspect of it. Because if they are able to give the decryption of the keys, then yes, to some extent, this problem gets solved. But on the other hand, the anonymity of cyberspace is such that the moment you block one particular page or a web page, it becomes visible on another website or a web page. Things like onion routing, things like IP, proxy IP, softwares which camouflage the real identity of a criminal, makes it very hard. The nature of platform itself, the nature of medium itself is such that it is a technical challenge to block any kind of objectionable content, whether percolated through social media platforms or otherwise. So that is a technical challenge which remains in its place. However, to some extent, if decryption is given, then yes, to some extent, at least on the social media platforms, this can be curtailed. And the second aspect is the onerous burden on the commercial aspect of the problem, because if there are going to be companies putting in their infrastructure and facilities in India, how secure can that data be? If we are bringing in personal sensitive data, and now that the RBI has also said that there will be personal sensitive financial information of people of India would only remain within servers in India, not elsewhere.
Right.
That becomes very pertinent question, because are our servers or are our infrastructure that secure and foolproof that we can ensure this objective that is there behind creating all these laws is actually achieved. So that's something which is again something which we need to really introspect at this point and gear up for it.
Right. Chakshu, talking about the draft rules. Now, according to those rules, a grievance officer, the name of the grievance officer has to be published by the intermediary, and also the mechanism for redressal of complaints. How efficacious would that step be?
I think, Kriti, two or three things that both Sumibal and Kanika have pointed out which relate to the question that you're asking. One is the speed with which technology evolves, or the speed with which content and the load of content that evolves, and the rate at which regulation or laws can keep up with that evolution is a thing to be considered. I think one of the, and the 2011 rules first came up with the idea of, having a nodal officer who is available as a redressal officer for redressing complaints. That's one aspect of it. Now, what these rules are doing is they're casting an obligation onto the platforms and saying that they will proactively develop tools to take down, certain kind of content which is either unlawful or offensive. So that's one proactive step that's been taken. The other part that is being done is, and Kanika referred to it fleetingly, was that if you become a platform which has a subscriber rate above 50 lakh people, I think that's what the rules say, then the obligation for you to have a physical registered presence and a nodal officer and all of that kind of kicks in. Now, the idea for that is that if you are a platform which is big enough, then you should be investing in enough resources for redressing complaints. And the final part of it comes in from the fact as to then when you are a platform, you're a platform which is big enough, then you have obligations. You have obligations towards the state, and some of those obligations are to ensure that you cooperate with, the state agencies. That cooperation would involve, probably decryption of keys, or to provide the whole path of communication that happened, onto your platform. I think the key question is, what is the balance that you cast out between a state's interest of ensuring, lawful behavior, within the country, and a citizen's interest of having his or her information protected. And that's the tricky bit that these rules have to navigate.
Right, so we are talking about the balance. But Karnika, talking about the nodal officer, the presence of nodal officer in India 24/7 for coordination with the agencies, do you think that's a very progressive step in terms of, the government ensuring that there is no misuse of social media platforms?
Well, I think it will certainly bring in more quicker incident response, because what used to happen earlier was that we had the MLAT system, mutual legal assistance treaty system, or there would be an Interpol or a 24/7, some sort of a network which will help us, address these situations where there'll be, email communications or some sort of a threat in terms of cyberspace, which is there. And so to get that information by cooperation of international organizations or in fact any other jurisdiction was a challenge. So to get that synchronized, it was a huge, I would say, effort. Even legally speaking, even in government, from the government point of view, to get that kind of intervention and cooperation from the other side was difficult. And it would take sometimes 6 months or even longer timelines. By that time, the data would be erased or not available. So that becomes a challenge. And for that, from that perspective, yes, it will be a quicker action to get hold of the right information, provided they are able to cooperate in that spirit. So that's one thing. We don't have a cybercrime convention so far, India signatory to. That was one of the major hurdles, and I think from that perspective, this will be definitely a positive change. Again, there's a flip side. How these laws are implemented is going to be a major deciding factor in whether there is abuse or misuse, I would say, of law. So the procedures which have been put in place. There is a review committee reviewing the decision of the competent authority. There is a timeline given for retention of such data, which is like not more than 6 months they can store any kind of interception or even otherwise, any traffic, internet traffic. So surveillance, and if there's a blocking order, there has to be a reasonable basis for it. And if there is no alternative channel to get that data, only then there is, interception also. So these rules of interception and blocking, if you see them, mirror them, they're actually kind of identical in many respects, because the timelines are sort of the same, and also the reasonable basis on which these will be used by the agencies is also similar. So we have to see the efficacy. It lies in the implementation, and the more objective that implementation can be, the more chances of it being, within the confines of law or within the procedure prescribed by law. Because the moment they go otherwise, if it is a subjective opinion, if you say this is not a reasonable basis of law, how do you define that reasonable basis? There have to be more concrete, I would say, guidelines for a particular agency to address and have that, instead of having a subjective discretion to decide that reasonableness, there should be an objective criteria set for it.
Right. But talking about technical challenges, so Bimal, tell me, how do these social media platforms find out the genesis of misinformation or hoax to report to the competent authorities?
Well, you see, I think this is going to be the biggest issue, that their whole encryption ecosystem, that's today you can say the differentiator on which they are operating, where they get the number of subscribers, all of that. So that's something that's going to be really a challenge even for law enforcement or even the government, even with whatever rules and laws you bring in, to really extract out of them. But having said so, I think a period of time has come where a lot of I wouldn't say government is getting an upper hand, but at least the whole the ecosystem is realizing that the number of subscribers, the popularity with which the whole system has evolved, there is a need for all these intermediaries to follow certain rules that we define and not, go by the laws and rules of California or anything else that they often say to us and, delayed stuff. So I think a certain kind of I can't use the word control, these are very sensitive terms, but a certain kind of an upper hand we must have in trying to have a certain understanding of the scenario, because we still have a very sensitive society. Everything flares up on communal lines, ethnic lines, and in a very short time. And today, if you see the genesis of most of these flare-ups, whether anything you consider in the last 2 years, it's mostly the spread that goes via WhatsApp or maybe a little bit over Facebook and all. So the practice of democracy that we have, a healthy practice that we have had, and the practice of digital democracy, if you see, that we are trying to have through this media. We are not blocking anyone. We are not indiscriminately doing a surveillance on everyone. Even if you go back to the 2011 rules, when they were brought in, that provision of 36 hours, the response had to come, but everywhere it was construed that the whole content had to be taken off. So there is a lot of politics also that goes on in trying to project India as a kind of unfriendly relation as far as digital stuff are concerned. So I think, as she also said, the implementation, the actual essence of what we want to do, the whole idea, the whole philosophy behind all of this is to be able to give the consumer the best choice, which possibly will hinge a lot of implementation. Even when Supreme Court struck down 66A, but if you go back and see the cases, that led to the uproar, it was the misuse by the police in many places or the agencies that, showed that how possibly a point of law can absolutely go haywire if the implementation is not right.
That's why I said subjectivity has to give way to objectivity. I mean, you cannot have something which is just on the whims and fancies of any particular agencies in an arbitrary manner. It has to have a reasonable, sound basis and the legal criteria to meet that.
Right.
So it's not something in the air that, one would decide, okay, for me this is reasonable and this is not reasonable for somebody else. It shouldn't be this way. It should be a very objective criteria.
69A, whether for, the surveillance part or even the blocking part, I think the basis is very good. Exclusions under Article 19(2) of the Constitution. I think nothing bad in that.
But
we're talking
one
about
more thing which
yes.
is very pertinent is, supposing there's a surveillance, okay. Now, how does one citizen know that he's being surveilled? How does he understand? And in case he does and he wants to challenge it, there are a lot of things under Official Secrets Act that may not be shared with him. So these are questions, which will be posing a question mark to the right of freedom of speech or right of,
privacy.
I would say, privacy.
Yes.
And these have to be answered in a proper, manner, because at this point, things like these are directly, attacking the right to privacy.
Of course, we've been talking about the right balance, striking the right balance. But if you're talking about implementation, let's also talk about deterrence. What kind of deterrence would these rules create so that the users do not post obnoxious content?
I think this is definitely going to be helpful in that, because there's going to be accountability, there's going to be greater responsibility by the users, because then they will understand the implications of forwarding. Now that for example, WhatsApp has put a forward button.
Yes.
The moment you forward it to 5 people, it can't be forwarded further. Right. It's different with the group lists or the group broadcast. But having said that, it is definitely creating a deterrent. People are thinking twice before posting anything. There is liability attached to it. There have been court decisions where even admins of certain groups have been held liable, and in certain cases they have not been held liable for obvious reasons, that they had neither knowledge nor had any control right. on that particular
Chakshu, I'll give you the last word. How would these rules make our cyber security more robust?
Let me just kind of break it down first on the user side of things. On the user side of things, what these rules are saying is that the intermediary has a responsibility to inform the users every month about what are the guidelines for the platform. That's one. The second thing that's happening is that it is giving the security agencies the ability to go to intermediaries and track down offending communication, and then there are timelines provided for that. The third thing it's doing is that it's allowing for takedown of content based on the request of a court order or on the basis of a government agency's request within a specified period of time. And the fourth thing that it's doing is it's creating a proactive, position for platforms to look at the content which is on their platforms and then take down offending content by providing for some technical tools that they, kind of develop. Lastly, it is casting in obligations on platforms to say, if you reach a certain size, you have to provide for a nodal officer, you have to have a physical address where, the legal system can reach you. So all in all, that's what these rules are doing. Just one very brief intervention about what is the journey of these rules. There will be public consultation, the rules will then be notified, and then these rules will be placed before the two houses of parliament in case a member of parliament wants to amend or object to any of these rules.
Right, absolutely. On that note, thank you so much for joining us. So social media platforms would require to follow due diligence. That's all we had for you in this edition of Policy Watch. Thanks for watching and stay tuned to Rajya Sabha Television.